For those who I haven't met, my name's Michael Cassetto and I'm a partner at Berube Art in our corporate and commercial team. And first of all, I'd like to welcome everyone to Berube Art. And as I sort of mentioned, there's quite a bit of material to get through. So today we're going to be talking about some of the IP trends over the last 12 months. And in this update, we're not going to, it's a high level update, and I know that there's quite a few IP professionals in the room. Obviously in an hour we can't cover everything, so we're just picking out some of the things that we think are the most important trends or cases or changes to the law that we've seen over the last 12 months. Three parts to this presentation. There's three speakers. First of all, I'm going to be talking about some of the trends in IP. My colleague Jason Sprague will be talking about some of the interesting cases that have occurred over the last 12 months. Those cases are going to cover topics like trademarks, consumer law and copyright. And then lastly, Puriya is going to close off the presentation, Puriya Devuti, by talking about some of the regulatory changes over the last 12 months, concentrating on a couple of things. One of them really some of the changes arising as a result of the response to the Productivity Commission's report on IP arrangements, and also that big change that occurred in September about the removal of the safe harbour provisions for IP out of the Competition and Consumer Act. Looking around the room, I know that we're all believers in IP, and we all know that how important IP is to innovation and economic growth, so I'm not really going to sort of talk about that anymore. But what I will do is just take the opportunity to talk about some of the trends that we've seen over the last 12 months. And in talking about these trends, I'm drawing on information that we've gleaned from a number of reports, but probably mainly from the Australian Intellectual Property Report of 2019, which was published by IP Australia in April of this year. So there's some interesting trends that can be taken from that report. And then I'll finish off by talking about a couple of trends that we've seen just from some of the work that we're doing and some of the things that we see in the media. So firstly, okay, so trends, and when I'm talking about the IP trends, I'm going to talk about really two areas of IP, patents and trademarks, because they're the most common and probably the most popular. So firstly, just some trends in patents. As far as local filings are concerned, just a steady increase in filings, nothing too exceptional there. Although one thing I think that I noticed was that filings by Australian residents grew by about 8%. I'm not sure, what that necessarily means, but it might suggest that perhaps Australian businesses are becoming more innovative. I'm not sure. Maybe they're just becoming smarter and more aware of the importance of maybe having a patent application in their kit when they're going to market to raise capital. It's hard to know exactly what that is telling us. Technology fields, I think, is a more important thing to look at from the technology fields, and I'm not sure whether you can see it from the slides, but the most common technology fields of patents was in the areas of medtech, biotech, and pharmaceuticals. And that's really on trend with some of the things that are happening just globally. Ageing population, more innovation in medtech and health and life sciences. And also, it could just be part of the technology cycles. I mean, technologies come and go in different cycles, and that's shown also by the fact that civil engineering and patents in that space are in decline at the moment. As far as overseas filings, when I talk about overseas filings, that's by resident companies filing overseas. Those, again, nothing too significant in the sense that there was low growth, but an interesting fact that I gleaned from the report was that For every patent application in Australia, there's 3 that are made overseas. Right, so that's just an interesting statistic. Another thing that sort of came out of the report was that there was quite a bit of growth in filings into China. So, there was about a 8% increase in filings into China. So that's just another interesting trend, and I'll mention that a little bit later, or refer to that a little bit later. As far as trademarks, again, local filings, similar kind of steady growth, but it's just been steady growth for quite a number of years now. Unlike patents, resident filings only account for less than 10%, but in the area of trademarks, resident filings account for about 60% of filings. But the most interesting thing there was that there was an 11% increase in non-resident filings, so a lot more inbound trademark applications coming in. And again, probably more interesting was the fact that there was 27% growth in filings from China. So that's obviously suggesting that Chinese companies are looking to protect their brands more in Australia. Another thing with the classes that again just shows some of the areas that are important to businesses in wanting to protect their brands, and you can see, or the report showed that there was a lot of interest in technology, business services and education. So again, that's just showing that there's a bit of a trend of businesses starting or wanting to protect their brands in those areas. As far as filings by Australians overseas, there's just been a continual upward trend in those trademarks since about 2009, so it's just been steady growth all the way through. And that's probably just indicative of the fact that over the last 10 years, as the markets have really globalised, and businesses, when they're starting up, aren't just looking at protecting their brands or protecting their markets locally. They're looking at a global market, and that's just shown by the trends in trademark registrations. No surprise, the US is the most popular destination for trademark filings from Australia. But yeah, there was also a bit of a trend in trademarks being filed in China, so about an 8% increase of trademarks filed in China. Just another interesting fact that I took out of the report, maybe because I'm a bit of a trademark nerd, but non-use applications, while they doubled over the last 10 years, and I'm not sure whether people know, but you can make an application, or a trademark is susceptible to being struck off the register if it's not used. And the number of non-use applications has increased over the last 10 years, or doubled over the last 10 years, but it still only accounts for about 0.1% of all applications filed. Now, I'm not quite sure, I found that interesting, but and I thought I'd share it, but anyway, there you go. Other trends in IP, there's really 3 things that I was going to talk about here. Firstly, e-commerce. Obviously, e-commerce is booming. The fact that e-commerce platforms transcend borders can make it hard to police behaviour that happens on platforms. And there is a figure that's been thrown around that about 70% of all counterfeit goods are sold through online platforms. And that makes it really difficult for IP lawyers, because I'm not sure whether people have had the pleasure of trying to stop someone from selling counterfeit goods online. But if you don't have the cooperation of the e-commerce platform, it can be really difficult. And one of the things that we've seen is that over the years, people like Amazon and some of the other platform providers have been investing quite a lot in takedown mechanisms, so that, obviously if you can show that you are a trademark owner and that you have a legitimate case, then they have some mechanisms in place which can take down counterfeit product from their platforms quite quickly and swiftly. And that's certainly something that has been welcomed by brand owners. But like with a lot of technology, when mechanisms are created to beat the bad guys will come up with new technologies or new ways of getting around that. So one of the things that we'll see over, I think, the coming future is that technology and collaboration with e-platforms will continue to evolve, because we'll have to stay on top of the technologies to make sure that we can combat counterfeit goods. Another area is the views on China. And, obviously Western governments have long complained about the poor enforcement of intellectual property in China. Obviously the US administration has been one of them. Trump is continually complaining about China. That's been one of his one of the things he's been talking about a lot, as well as everything else that he complains about. But the views on China and enforcement of IP in China are changing, and I think certainly this year we saw that China opened up some specialised IP courts, so they have invested quite a lot in developing their IP infrastructure, and as I mentioned earlier this year, a series of specialised intellectual property courts opened up in places like Beijing, Shanghai, Guangzhou. And the other thing is that China has quite a sophisticated customs system, and so they're quite good at stopping product at the border. The other thing, and I think that's also probably, that whole trend of that shift in the way that China is perceived from an intellectual property point of view is also reflected by the patent filings. As I mentioned before, there's been that 8% increase in patent filings in China, so people are becoming more comfortable in trying to protect their IP over in China. The other thing is with China becoming a leader in some technologies like green technology and AI, if you don't start collaborating or looking to collaborate with Chinese companies, then you might get left behind. Another area, interestingly, I think is FRAND licensing. And with digital technology reshaping the world, the interoperability of technology is becoming more and more important. And that means that businesses need to start rethinking some of their IP strategy. Enforcing a patent which will then restrict others from using a technology is not necessarily conducive to building a healthy sort of technology ecosystem. So there's been a call for businesses and governments and regulators to encourage that value of commercial IP licensing on fair and reasonable non-discriminatory terms, and that's what FRAND licensing is: fair, reasonable and non-discriminatory terms. And just to illustrate that point, all you need to do is just think about the technology that would be required for a self-driving vehicle. Right? So you can imagine all the different types of technology and systems that would need to interoperate. They're not going to come from one party. They're going to come from a whole bunch of different people, and those people will need to collaborate and work together. And FRAND licensing is just a way of ensuring that people can license their technologies to each other on fair and reasonable terms, and I think that's something that will emerge over the coming years. Anyway, so that's me, and that's the emerging trends, and I'll hand over to Jason Sprague. Thanks.
There we go, right way. So I'll give myself a high bar. I've called it interesting cases. Now, what might float my boat as an IP lawyer may not float your boat, but that's the way this seminar is going to run, okay? Having said that, I've taken some cases from copyright, Australian consumer law and trademarks, and the cases themselves actually have quite significant impact upon everyday business and everyday lives. So our IP can be a bit of an esoteric concept at times and quite confusing, but the simple fact is that it underpins so much of that we do. So this is going to be high level, as Michael said. There's a few cases I'm going to run through. I won't do a deep dive into some of the analysis, just sort of the highlights and things to consider as we sort of go through these various cases. And the first case I've selected from the copyright world is purely just interesting. Unless you're in the music industry, which makes it even more interesting. And that would be the recent decision in August in a US decision, jury trial, where Katy Perry's Dark Horse song was found to have infringed a song called Joyful Noise. Have you ever heard of Joyful Noise? No. Not surprising. It's actually a rap song, so even the title's oxymoronic. I mean, rap, joyful noise, doesn't quite go together. At least that's what my father always used to tell me. But anyway, the outcome of the trial has been a $2.5 or $2.7 million US dollar damages verdict against Katy Perry and the songwriters, with a $500,000 verdict against Perry herself. The concerns with this particular verdict is that it brings into question, what does copyright protect? How far does it go? Generally with copyright, it's a fairly low threshold to what can be protected under copyright. But there are certain things which shouldn't be able to be protected by copyright, and they're the general everyday, run-of-the-mill, fairly building blocks, I suppose, of creativity and artistic work. The concerns which this particular decision has raised is that the musical notations called ostinatos, and for those of you who aren't music theorists like myself, I had no idea what that meant. It's actually a very short piece of music which underpins the entire song. It forms the beat or the rhythm and the feel of the song. Here we have 3 scores. The first score is actually taken from Joyful Noise. The next 2 are taken from Perry's Dark Horse. The second and third pictures are actually the same musical notation, but one's just sped up. But you look at it and look at the notations and go, well, they do look pretty similar. Maybe there is a bit of copying that's gone on. And interestingly, when this claim was made, rather than the actual musical work being the source of copyright claim, it was actually the underlying composition, so that the notations. And it was focused very narrowly on these particular short pieces of music. Now, just to give you an idea of what this all means, it's easy to talk about this in theory, but you've actually got to hear it. So hopefully we can get the sounds up. This is from Joyful Noise. And this is what they're arguing about.
You know what it is?
Okay. And you hear that at the end? You know what it is? Just keep that in mind as well. I think that might have had a bit of an impact on the jury's decision. And this is from Dark Horse. Okay. Does that sound the same? No? No, it sounds different. And interestingly, when you look at the musical notations, it is different. You've got the notation from Joyful Noise, which is actually C, B and A. It's a 3-notation ostinato. Anyone from the CBA here? No? Good? Okay. I shouldn't say that. Now, in terms of the one for Katy Perry, it's actually a 4-note ostinato, and that's actually D flat, C, B flat and F. So you've got to think, well, how can that possibly be the same? But with copyright, it's about substantial similarity. And the way that it was viewed was to underpin the scores of both of these songs, which overall, when it was constructed as a fundamental building block, had various similarities. And therefore, as far as the jury was concerned, they said it's a copy. Now, this is being appealed by Katy Perry, and the feeling is that it should be overturned, because why should a fundamental building block to create a musical score be given copyright protection? Katy Perry's lawyers actually put on evidence to say, well, there's hundreds of songs that have very similar underpinning scores. It simply sets the beat and the tone of a piece of music. And the other concern with this particular case is that copyright and intellectual property laws in general are designed to facilitate creativity. This sort of decision actually undermines that and prevents creativity by locking down fundamental building blocks in terms of musical compositions. So to watch this space, we'll see what happens, but it's not an unusual situation. We probably remember the Men at Work case where they copied the flute riff from the Kookaburra Sits on an Old Gum Tree song. And also, for those of you who were born in the, or not born in the 80s, but rocked out in the 80s to Vanilla Ice's Ice Ice Baby, guilty, it was actually deemed to have copied the opening sequence of Queen's Under Pressure. So it's big business in terms of music, but it just also highlights the fact that copyright can be quite a complex and detailed area in terms of infringement. So if there is an infringement claim lobbed on your desk, give us a call. The next one was also about copyright, but it's about the innocent infringement case. I've got to quickly scroll through these. There we go. And this is a spotlight case. Now, people often say to me, I didn't know that it was copyright. Aren't I innocent? No, you're not. As the old maxim goes, ignorance is no defence in the eyes of the law. However, innocent infringement is a good defence if you can access it. The key things for innocent infringement are that on a substantive basis, should you have known that the work was, or what you did was going to be a breach of copyright? And objectively, how could you have known, or should you have known, that the work that you've taken was a copyright piece of work? Now, in the Spotlight case, Spotlight's representatives and the Dempsey Group, which actually markets the Morgan & Fitch brand through their bed, bath and table stores, both share a common supplier. And that supplier is a Chinese fabric company called Yantai Pacific Home Fashions. Both had a long-standing relationship with that supplier. Now, Dempsey, when they found Spotlight, well, Spotlight actually gone to Yantai and said, we like those designs, let's put them on our quilts and our bed covers and start to flog it. And again, that's where you can see that designs go into everyday life. Quilt covers, sheet sets, those sorts of everyday, mundane, I suppose, items. Spotlight then, I put Spot Type. There we go, that was good. Basically started to market it, put it in some catalogues, sold some products. Dempsey said, hold on, here's a letter saying that we actually own it and you've infringed our particular copyrights. Spotlight then took very, very quick action to recall the products already out there on the shelves and stop the infringing conduct. And that's an important thing in terms of managing any copyright claim risks. Now, Dempsey alleged that Spotlight knew, or should have known, that the works were Dempsey's because they alleged that they saw them under a bed, bath and table stand at the supplier's offices in Beijing. Now, Spotlight said, no, we didn't. We didn't say that at all. We had no reason to believe it was copyright. And we relied on our supplier to tell us these things. Now, that's a key point because the court said, you know what, that's a fair thing. You've both had long-standing relationships. The supplier should have pointed out to you that that was actually owned by another one of their clients, their customers. The question that comes into mind is, how long does that relationship have to be in existence? If you've just started a relationship with a supplier, is it really up to them to tell you what might be owned by somebody else? I don't think there is that obligation on them necessarily. You need to make inquiries of your supplier. So it's always a situation about what reasonable steps have you taken to check about copyright works or copyright that exists in other works that you might be taking. One classic thing I always hear from people is, it's on the internet, it's public domain, therefore I can take it. No. Anything on the internet is still going to have some copyright protection in it. If you want to use it, then you need to find the source of it and see if you need to get permission, unless you can use some of the exceptions, which I'm currently doing right now with the fair use to educate people. I mean, you can see here, don't laugh, Michael, this is educational. So you can see this, hopefully these pictures are clear, and it's quite clear that they're the same design. Now, I've also got a client in the US at the moment, subject to a claim out of the US for a similar situation where they're a fashion designer, they've obtained fabric from a Chinese supplier, made clothing, sent it to the US for sale, and they've been hit with claims by some parties in the US. That's our view is it's copyright trolling, because what often happens in the US is companies will take designs from wherever they find it and then file it on the copyright register in the US. They then wait for somebody to actually use it in the US and then go, right, you've infringed our copyright, pay up. The problem with the US system is they have a statutory damages regime, which we don't have in Australia, and that statutory damages regime can be quite scary in terms of the amount that you could be asked to pay. So rather than fighting some of these situations, people just roll over, say, here's $5,000, thanks very much, walk away, and people are very happy and that they make money off it. But again, the conduct, if there is a claim, has to be addressed very, very quickly. So basically, cease and desist, check it out. If there's any doubt, withdraw products from sale, which is what my client has done. We're just considering what to do in terms of the claim. If we roll over, we fight it. Now, what is the purpose of innocent infringement? Does it mean that you aren't an infringer? No, it doesn't. But what it does do is it means that the owner of the copyright can only sue for loss of profits rather than for damages. And they can elect either damages or loss of profits in the general scheme of things. The benefit of limiting it to a claim for lost profits is that it's usually going to be a lower amount. A damages claim can cover a much broader spectrum of issues, including loss of reputation, royalty fees. We may have license arrangements with third parties that have been lost. So the quantum is quite significant in terms of the differential generally. The benefit of that is if you can mount the defence of innocent infringement, the claim might actually disappear and go away because it may not be worth fighting. Once you've stopped the infringing conduct, the claim becomes not worth pursuing. So again, it's that very quick response. And once you've been put on notice as well, make sure that you do cease the conduct. If you continue the conduct after being put on notice, the innocent infringer defence will no longer apply and you may be subject to a damages claim. All right, misrepresentations under the consumer law. The case I've picked out here was the Berube Art case. This is a fairly straightforward case in terms of its facts. Basically, a company was selling souvenirs which had Aboriginal designs all over it. They said it was Aboriginal art. They said it was Australian. They said it was genuine. Actually, the art was basically the ideas were taken from Aboriginal art designs. They weren't actually Aboriginal art as such. They weren't genuine, actually made in Indonesia and done by Indonesian people in a factory. And they weren't Australian because they were imported from Indonesia. So it was quite an open and shut case in terms of the ACCC being able to say you misled people. What the key things were here was that the ACCC was able to impose a $2.3 million fine on this particular company. This company sold about 50,000 units of their products before they were caught, so not an insignificant number. But the fine is a very high number in terms of these sort of claims. So what it shows is that the ACCC is quite serious in terms of the penalty it tries to impose. Now the subject matter of this particular case revolved around Indigenous art, and there's a lot of sensitivity around how do we protect Indigenous art and Indigenous heritage. Not just in Australia, but globally there's a movement for that. And this case also illustrated that the actual IP laws that we have in Australia may not be sufficient to protect Indigenous works. See, and copyright protects the actual form of the work, not the ideas behind it. Now, the images we have here is actually a work which we commissioned for NIDOC Week, which hangs in one of our boardrooms. On the side there as you enter. So when you go past, that's actually what the picture from that. Now, there have been some moves to try and introduce new legislation specifically designed to protect Indigenous artwork and heritage. They were introduced in 2017, but they haven't actually been able to go forward, hasn't been supported. Now, protecting heritage with specific legislation is not new. We protect the word Anzac, we protect Olympic insignias, and those things are very similar in terms of what people are trying to achieve with Indigenous artworks. So again, it's in a bit of an evolving area. So if you're in the art space or involved with Indigenous works, then certainly it's an evolving area. Okay, distinctiveness, reputation. I get a lot of clients who come to me and say, I'd like to trademark this, and it's a very descriptive term. Let's just say, a very poor example, I'll admit. They say, we've got a soccer ball. We want to trademark the word round soccer ball thing. Just describes that, it's a round soccer ball. Great, okay. Chances, pretty much zero. But people think that if it's a trademark which is an everyday word, I can stop other people from using it. So there's this push to try and get these marks accepted. There are special circumstances where they can be accepted, but it's quite the exception rather than the norm. Now, in the Aldi Foods and Moroccan Oil case, there was two elements to this. The first one, which I'll talk about, is Moroccan Oil actually countersued against Aldi in relation to the Protein Naturals trademark which Aldi used. The issue at stake here was Moroccan Oil said Aldi's trademarks were misleading because it had the word naturals on it. And this is for a shampoo product. Everyone knows about Palmolive Naturals. This is Aldi's view, Protein Naturals. Only problem being is that the evidence that was led showed that there was nothing particularly natural about the product. It was all synthetic. So again, not a very hard position for the court to take to say, well, clearly you've misled people by using the word naturals on a product which is not natural at all. And that just is a take-home point. If you are marketing your products or advertising your products, making certain claims, the claims have to be justified. They have to be able to be backed up by something substantial or substantive. Now, the main issue about this case was Moroccan Oil tried to register the words Moroccan Oil as a trademark, and Aldi opposed that application. The picture there of Moroccan Oil is actually current registered trademarks for Moroccan Oil. Now, why that was successful and the word by itself wasn't is there is a large M in the trademark, which gives it a distinctive feature or character, which is probably why it was accepted by IP Australia as a registrable trademark. Absent that M, the words Moroccan Oil are simply descriptive. And this is what Aldi led with to oppose the application. They simply said, look, it's oil from Morocco. Okay, it's argan oil, but evidence was that that argan oil was coming out of Morocco. And further, other traders have been using the definition or the term Moroccan oil to signify that we're getting this oil and sourcing it from Morocco to put in various products. So the court said, well, quite clearly it's just descriptive of where it comes from. Therefore, there's no inherent ability to register the trademark. It doesn't actually, provide any identity of where your goods and services come from in terms of that company. So the opposition was successful, and the word Moroccan oil was not allowed to proceed to registration. In terms of the other issues around Moroccan oil, the evidence that was led by Moroccan Oil was saying, well, hang on, we've actually been marketing this for a couple of years. We've been doing our thing out to the consumers to try and get reputation in this word to identify it with us. Unfortunately, it's a very high threshold to get over in terms of a ordinary, everyday, common word being able to be identified as a trademark, which identifies you. And people go, oh, I see that word, I think about it being the product which belongs to a certain company. What the court found was that while Moroccan Oil had been distributing the product for some years, in the initial phases, it was only to distributors to say, look, here's this product, please mark it on your shelves and sell it, the usual sort of thing. It hadn't been marketed heavily to the public. It was only a period of 2 years where they could show that actual marketing to the public had taken place. And that 2-year period was just simply insufficient for the reputation to have been generated. The next case is one which I was involved with this year, and it goes to, again, this issue about distinctiveness and reputation. So Suzanne Gray Corporation, everyone knows Suzanne Gray, very well-known clothing retailer, and my client Suzanne Betra was also in the fashion industry, but they're based predominantly out of China and sell mostly into the US. Now, they made an application for the trademark Suzanne Betra, which is actually the designer's name. This was opposed by Suzanne Gray. Now, yes, there was arguments about substantial similarity and a range of other issues, but clearly Suzanne Gray, Suzanne Betra are quite dissimilar in terms of the Gray and the Betra components. It's just the element of Suzanne. So what happened was Suzanne Gray said, well, hang on, we've been in business for about 50 odd years. We've used Suzanne Gray for 50 years. If anyone sees Suzanne, then they'll know it's us. Now, the question was, well, hang on, you've also got a stablemate called Suzanne, S-U-S-S-A-N. How does that mean that this Suzanne means it's you? Oh, because it's S-U-Z-A-N-N-E. That's different. Now, some might think, well, yeah, that makes sense. But Suzanne is a common name. It's very common. Should anyone get rights in a name like that? The answer in this case was no. However, the reason for that is because the evidence that was led was that Suzanne was never used by itself by Suzanne Gray. It was always Suzanne Gray. And ironically, even on their website, when they actually did separate the marks, they always referred to grey. So even in their own advertising, grey was a distinctive element. So life is better in grey, or choose your grey. So ultimately, what this came down to was, notwithstanding that they've been in business for 50 odd years using Suzanne Grey, there was no reputation developed in the name Suzanne by itself. And that follows, the standard, or what should have been the outcome, because the name Suzanne is a common everyday name for a lady, and why should somebody get that right to use that name by itself? And again, harking back to the 80s, a bit of reference to the Madonna movie, Desperately Seeking Susan, if those of you can remember that one. And not Suzanne. All right. Unregistered common law trademarks. This was quite an important case in terms of the rights that go around common law marks versus registered marks. It's quite common for people to license common law marks which aren't registered, along with registered trademarks. The problem is that registered trademarks do give a much higher level of protection. You have statutory rights which apply under the Trademarks Act. If you don't have registration, you've got to rely on either the consumer law for misleading and deceptive conduct or the common law tort of passing off. Those are designed to protect goodwill, where a registered mark has very, very clear rights and remedies within the Act. So there's a little bit of background here in terms of setting the picture. So Kraft Foods Kraft Australia Limited owned the trade dress and get-up of the classic Kraft peanut butter jar, which we've all known and loved over many years. They restructured. They then put Kraft Australia Limited into Mondelez Foods, and then Kraft LLC, being the big parent company, did its other things. Mondelez assigned the trade dress and the goodwill to Kraft LLC, which then licensed it back to Mondelez to use. Mondelez then sold the peanut butter business to Bega. After Bega had acquired the business, which included all the goodwill of the business, Kraft then put an application in for these trademarks for the get-up. Bega then sent out their peanut butter in these jars saying, we're now the peanut butter kings of Australia, and used the get-up, which everyone was very familiar with, which of course that's what you would do. It's continuity of brand, it's recognition, people will continue to buy it. Now, the sales of peanut butter for the Kraft brand is about $60 million per year, so not peanuts, pardon the pun. Kraft Foods said, stop, you can't use that, it's ours. We've had it assigned to us by our subsidiary, Mondelez. Bega said, no, we bought all the goodwill, we bought the business, we bought everything from Mondelez, so, you can't have it. The court upheld Bega's position, and it's a legal principle that the goodwill in unregistered trademarks sit with the business. They can't be assigned or dealt with separately. So while there was a written assignment between Mondelez and Kraft LLC, that was ineffective under Australian law. And the argument that Bega ran was based on existing principles, which is, I think, one of those ones that's often forgotten, that the goodwill in an unregistered trademark is indivisible from the goodwill of the business as a whole. That's not the case with the registered trademark. With a registered trademark, you can do what you like with it. It's a divisible piece of, it's an asset which you can sell, license, do whatever you like with. Unregistered trademarks do not have that ability. And that's what the court said. It said, I'm sorry, but Bega bought the business with its goodwill and the trade dress, everything that went with it, was indivisible. You can't take away the trade dress from the goodwill in the business, the two are tied together. Absent goodwill being sold by Mondelez to Kraft LLC, there was an ineffective transfer of that particular trade dress. Now, an application can also be subject, so application has been made can also be dealt with as if it was a registered trademark. The problem for Kraft Foods in this instance was when they restructured, they didn't actually assign the goodwill or sell that business to the parent company. It was just the trademark. And the court said, no, trademark stays with the business. If they'd sold the business or made the applications prior to the sale or the restructure going ahead, it may have been a very different story. The court may have said, well, that is actually something which you can assign and deal with. The take-home point for this one is really, if you have unregistered trademarks, maybe you should think about registering them, actually looking at what the rights are, what you're trying to do with them, because they don't have the same protection, they don't have the same impact as a registration will provide. So it's just a key take-home point. We often think, oh, it's too hard to register, I don't want to get it done. But common law has its limitations, and that the bigger case is a clear case in point. Okay. Trident, control of trademarks. Now this one has a bit of a history. I've actually put these probably in the wrong order. The seminal case here is a Lodestar case, and that was the use of a trademark called wild geese. And what came out of that particular case was you have to, if you're a licensor of a trademark, you have to exercise control over the trademark, actual control. Now, the issues that arise in this, the context which these issues arise in are usually in opposition proceedings, where somebody is saying, oh, you haven't used your mark, I'm going to remove it from the register. That is defensible if you can show that you've used it as the owner, or a licensee has used it under the owner's direction and control. Now, the Lodestar case was a 5-member federal court case, which signified it was fairly important. But the upshot of that was, even though that the companies had an agreement between them about the trademark, with the trademark licence in place, and there was obligations around control and quality and everything else, the owner had not actually done anything. There was no oversight, no evidence that they'd actually enforced any of these terms, done anything to maintain that control. So really the licensee was doing what it wanted to. Now that was a big shift in thinking and how owners had to control their trademarks. It's become quite loose and lax before that. So the next two cases which have been decided recently was both Calico and Trident, and I think these are a little bit inconsistent myself. Calico was a situation where a gentleman by the name of Kevin Owens had a trademark, Mark 184. He assigned it to a company, Calico Proprietary Limited, of which he was a managing director and owned 50%. That assignment wasn't registered, which has a few of its own problems, but ultimately the court was okay with that. On the same day that the assignment took place, Calico then entered into a license agreement with Calico Global Proprietary Limited. Again, a company which had Mr. Owens as a managing director. Calico Global was controlled by Calico. Again, Mr. Owens was a controlling mind, and that's the argument that was run to say, well, he's a controlling mind of these entities. Therefore, we're exercising control over the mark and its use. The court's view in that case was actually, no, they're different entities. That doesn't flow. You don't have the requisite control. Now, there were other elements in there around a lack of evidence of actual use during the case, which I'm sure probably coloured the judge's decision. But he was quite specific in saying, you've got different entities. It doesn't matter if you have the same managing director and you've got a 50% controlling interest in the parent company, which then controls a subsidiary. That doesn't really have a bearing. There has to be actual evidence that control is taking place. Compare that with Trident. Trident introduced a unity of purpose test. Now, Trident Seafoods, big organisation, international, clearly deals with seafoods. And Trident, which most people probably know from the noodle packets, my son loves these noodles, they do a lot of Asian food that they market under the Trident brand. So Trident Seafoods, again, was blocked by Trident when they made some trademark applications. So Trident Seafoods said, right, we're going to log in a non-use application against Trident to try and remove these blocking marks. The difference here was that Trident had actually licensed its parent company to use the Trident brand. Now, you might say, well, how does the subsidiary control the parent? It doesn't quite make sense, but again, there are ways you can do it. However, that's not really the issue here. The issue is the judge said, you know what, you've got the same directors in the parent company as you do the subsidiary. It's a wholly owned subsidiary. The directors have a unity of purpose in that they're using the mark and trying to do the best to get the most out of the mark in terms of protecting it, promoting it, using the brand to its fullest extent. And that unity of purpose was sufficient for them to say, well, the subsidiary control aspect is there. Even though, again, there was no actual evidence of review, control over quality, everything else between the two companies, the fact that the directors were common, they said, well, that's sufficient, that's enough. So that contrasts quite differently to the Calico situation. The good news is, for those in corporate groups and licensing arrangements within corporate groups, it makes it a bit easier in terms of saying, well, we actually are controlling the trademark and we are looking at how it's used in the marketplace. Therefore, if there are non-use applications that are filed, it's a bit of a harder bar to get over, and you should have a slightly better position or being better protected. So that's basically a bit of a wrap-up of some of the things that have happened in the IP space last 12 months and some of the case law. And we'll now look at the regulatory changes, and I'll hand over to Piria.
Thanks again to everyone for coming today. Just a disclaimer, so I am going to be talking about some of the changes, the recent changes in the legislation. So unfortunately, I probably won't be having any rap videos today. Hopefully some of this content will still capture some of your attention. So why the recent regulatory changes? Oh, I got it right. In 2018 and 2019, there's been quite a lot of activity in the world of IP regulatory reform in Australia, and more changes are yet to come in the near future. A lot of the recent changes, as Michael pointed to before, have come about on the back of the Productivity Commission's public inquiry into Australia's IP system in 2016 and the government's response to that report in mid-2017. Today I'm going to provide some high-level commentary on the changes while considering some of the key changes in a bit more detail, and hopefully point out some of the main issues that IP owners might need to look out for going forward. To start with, I think it's important to quickly discuss the overarching intention of most of the recent regulatory reform. So many industry folk and commentators have suggested that the overarching purpose for making these recent changes is to diminish IP rights in Australia and encourage more competition. Interestingly, the Productivity Commission took the view in its report that intellectual property rights and competition law are not in fundamental conflict. The apparent rationale behind that is that intellectual property rights and competition law share a common purpose in promoting innovation and enhancing consumer welfare. Parliament also appeared to agree with that rationale in making the very recent amendment to the Competition and Consumer Act to repeal the IP exemption, which I'll talk about a bit in more detail a bit later. However, while it might be too extreme to say that intellectual property law and competition law are in fundamental conflict, I think there has always been some consensus that there is at least some conflict. Personally, I've always agreed with the view that there is and always will be a tension between intellectual property laws on the one hand, which are arguably designed to register or recognise and protect monopolies, and on the other hand, competition laws, which are largely aimed at promoting competition by stopping businesses from acquiring monopoly or market power, or at least stopping them from misusing their market power. So I thought it would just be a good idea to keep that in mind as we go through some of these recent changes, as I think we'll find a sort of common underlying theme where lawmakers are leaning towards more of a focus on the promotion of competition rather than the scope of protection that should be afforded to IP rights in Australia. So the first piece of legislation passed in response to the Productivity Commission's report is the Intellectual Property Laws Amendment Productivity Commission Response Part 1 and Other Measures Act. We'll call it the Part 1 Act from now on. It includes a number of measures intended to streamline and align the administration of the Australian IP system, along with a number of other measures which are mostly related to the enforcement of plant breeders' rights. IP Australia said that these measures will basically improve a lot of the administrative matters and simplify the processes and reduce the time customers and IP Australia need to spend on admin and processes. So And if anyone's tried to apply for a trademark in Australia recently, you'll probably know about the kind of administrative delays IP Australia is experiencing at the moment. Other key changes which we'll consider in a bit more detail include a change to the Trademarks Act to clarify that the principle of trademark exhaustion does apply in Australia in relation to the parallel importation of legitimately marked goods, and changes to the Trademarks Act, Patents Act and Designs Act to allow courts to penalise businesses for flagrant unjustified threats of IP infringement. So the first one, parallel imports are genuine goods which have been legitimately branded with a trademark by the owner of the trademark or some other person authorised to do so in another country, and then obviously imported into the relevant country. Prior to the recent amendment in the Part 1 Act, the government argued that Section 123 of the Trademarks Act was already aimed at allowing for parallel imports in Australia. However, Section 123 was generally read narrowly by the courts and held not to apply where the owner of the registered trademark in Australia is a different entity to the entity which owned and applied the same trademark in the country in which the goods were originally purchased before being imported into Australia. The Part 1 Act has now inserted a new Section 122A into the Trademarks Act, which clarifies the point that parallel imports will not constitute trademark infringement in Australia if the goods have been brought to market in another country by the registered owner of that mark or another person that has a commercial relationship with the registered owner. This concept is usually referred to as trademark exhaustion because the registered owner's rights are considered to be exhausted once they market their goods in their home jurisdiction. The effect of this change is that trademark owners will no longer be able to prevent parallel imports through simple differences in ownership arrangements. While this change is definitely good news for importers, it could also have some negative effects on the market and consumers. Packaging for products is often tailored for each country to deal with different labelling standards and differences in price, quality, guarantees, etc. So consumers relying on the trademark when buying the goods might be purchasing a parallel import without knowing, which might not meet their expectations for that particular product. Ultimately, this could also have further negative impacts on the goodwill which the owner of the Australian trademark has acquired in the Australian market. Flagrant unjustified threats. The Part 1 Act has also introduced a discretion for courts to award additional damages against owners of IP rights who flagrantly and unjustifiably threaten another person or business with court action for IP infringement. The previous level of damages for unjustified threats of infringement proceedings was said to have been insufficient to deal with some threateners that might take advantage of their size and position to scare off competition from smaller fish by unjustifiably threatening to take them to court. It's because the considerable benefit that a well-resourced business may gain from making an unjustified threat could potentially far outweigh the usual cost of compensatory damages that could be awarded to the party that they are threatening. In terms of what kind of conduct would be considered a flagrant unjustified threat, there's no definitive list. The court will look at the individual facts of each case in order to determine whether the conduct was flagrant or not. However, it's likely that it will be a high threshold and that the conduct will need to show a calculated disregard of the other party's rights or some cynical pursuit of benefits in bad faith. The likely impact on IP rights holders is that they should think twice and perhaps obtain advice before shooting from the hip with a rapid-fire cease and desist letter, as the other party they are threatening might call their bluff and commence proceeding against them for unjustified threats, which if found to be flagrant could now involve significant penalties at the court's discretion. So another recent change in the Treasury Laws Amendment and the repeal of subsection 51.3 of the Competition and Consumer Act. So prior to 13 September this year, subsection 51.3 of the Competition and Consumer Act provided an exemption from the operation of certain competition laws, including prohibitions on cartel conduct and anti-competitive agreements, to the conditional licensing or assignment of IP rights. The strength of the protection afforded under the IP exemption was always a little uncertain, as it was rarely tested by the courts. However, many IP rights holders relied on the exemption to include restrictions on use of their IP in a way that may otherwise have contravened competition law. As I'm sure many of you are probably aware, that subsection was repealed earlier this year, and there will be no grandfathering, which means that the repeal applies to all existing and future licenses, assignments, contracts and arrangements. The following provisions under the CCA, which were previously the subject of the exemptions, will now potentially apply to all IP deals. So number one is the prohibition on cartel conduct, including contracts involving price fixing, output restrictions, market sharing and bid rigging. The second of the anti-competitive provisions that may now apply is the general provision on making or giving effect to a contract or arrangement under section 45 of the CCA for the purpose or with the effect or likely effect of substantially lessening competition. And the third provision that may now apply to certain IP deals following the repeal is the prohibition on engaging in exclusive dealing under section 47. And of course, the prohibitions against misuse of market power and resale price maintenance will continue to apply, as they were never covered by the exemption, sorry. So the ACCC's released some guidelines on the repeal with the aim of outlining the types of previously exempt conduct that may now be subject to the provisions and providing some examples to illustrate conduct that the ACCC considers is likely or unlikely to contravene the cartel provisions and sections 45 and 47. Some interesting points from the ACCC guidelines to think about. Firstly, the guidelines set out for cases involving an analysis of conduct with the effect or likely effect of substantially lessening competition, the ACCC will apply a with or without test. This involves comparing the likely state of competition with the relevant conduct to the likely state of competition without the relevant conduct. Applying this test to licenses or assignments of IP rights, the ACCC expects that in most cases the without scenario would be that there is no IP license or assignment at all. And if this is the case, the ACCC also considers that most licenses or assignments of IP will not involve any substantial lessening of competition, as even a license with restrictive conditions will allow for greater exploitation of the IP rights as opposed to no license at all. Regarding cartel conduct, the ACCC has taken the view that IP licenses between competitors which contain territorial restrictions, price restrictions or output restrictions are likely to be prohibited as cartel conduct, but only so long as the relevant purpose or purpose/effect condition is made out. As discussed, the ACCC guidelines also include the ACCC's work through examples for specific types of agreements and conduct involving IP rights and how they would apply the test we've been talking about to those examples. Interestingly, and this is probably a testament to how complex and uncertain this area of law is at the moment, the ACCC has changed its position in the final version of its guidelines in relation to a number of the example scenarios that the ACCC initially published in its draft version earlier this year. For example, one of the hypothetical scenarios regarding cartel conduct involves a patent license between two steel manufacturers who are likely competitors. A condition of the license is that the licensee is restricted in respect of how much of the patented steel the licensee can produce. The ACCC initially took the view in the draft guidelines that this restrictive condition would likely be a cartel provision. However, the ACCC takes a different view in the final version of the guidelines, released in August, on the basis that the licensee would be able to supply more steel than it could have done if it didn't enter into the license, so the parties could not have intended to have restricted or limited the supply of steel by the licensee. As usual, it's ultimately a matter for the courts to determine how the competition law lens will be applied in the context of IP licenses and assignments following the repeal. Who's most likely to be affected? Businesses that are most likely to be affected are those that regularly license or assign their IP rights with conditions or restrictions, including pharmaceutical, IT and telecommunications businesses. There are a number of potential risk areas. I know we're strapped for time a little bit, so I'll just run through these quickly. Many commentators have pointed to these as being some of the key risk areas: territorial restrictions and field of use restrictions, where use of IP rights are limited to a specific territory or field; price restrictions, being licenses which restrict or put conditions on the price of goods; patent pools, where patent owners license their patents to one another or to third parties. Businesses participating in those run the risk that they are undermining competition; cross-licensing, involving agreements between two parties to grant licenses to one another, likely to amount to cartel conduct if the two parties are competitors, and particularly if the cross-license is exclusive. And then there's also extended license terms and grant-back obligations, which are quite common clauses in IP licenses. Final note on the ACCC: there is an option available to businesses who fear that their IP arrangements may contravene competition laws following the repeal of the IP exemption, and that option is to apply for authorisation of their existing arrangements. However, this could be difficult considering the ACCC has 6 months to make a determination in relation to an application, and further, you would need to prove that the proposed conduct is likely to result in a public benefit, which is where the likely public benefit resulting from the conduct outweighs the likely public detriment. So that can be a bit difficult. Finally, I'll just talk about upcoming law, the second piece of legislation on the back of the government's response to the Productivity Commission's report, passed the Senate yesterday. It's largely focused, this bill, the Part 2 bill, is largely focused on amendments to Australia's patent system. One of the key changes, particularly for businesses with reasonable patent portfolios and of course patent attorneys, is the phasing out of the innovation patent system. So I'm sure many of you know the innovation patent system was established with the objective of stimulating innovation in small to medium-sized enterprises by extending patent protection to inventions which don't maybe meet the higher inventiveness threshold required for standard patents. And it was also a quicker and cost-effective and easier process. The Commission found that the majority of these small to medium-sized enterprises who use the innovation patent system do not obtain any value from it, and that the system imposes significant costs on third parties and the broader Australian community. So they recommended that it be scrapped, and the government has agreed. It looks like the innovation patent systems will begin to be phased out very soon. However, the phasing out is likely to be a slow burn, as the system will continue to operate for innovation patents that were filed before the amendments commence. It looks like it could effectively be 9 years or so before we see the last of the innovation patents. And I know I'm over time, so I'll probably just stop talking.